All right, so we're going to go ahead and get started with the afternoon panel here. My name is Jessie Gable. I'm a professor of law here at Georgia State University, and I specialize in, I'm sort of a general jurisdiction person, but I specialize in forensic evidence and forensic medicine. And I also teach contracts and bankruptcy at the College of Law. And I'm going to have each of our panelists introduce themselves. We are a PhD-heavy panel bookended by two lawyers, particularly a judge. So I will turn it over to Kate.
Sure. I think I was introduced earlier at one of the panels. So my name is Katerina Pivovarva, and I am a clinical forensic psychologist over at Mass General and a research fellow doing some neuroscience work over at Harvard.
Nicole Vincent, I'm a philosopher. I work here, and I'm glad that you will come.
I'm Felipe Urigarda. I'm a philosopher and a cognitive neuroscientist. I am assistant professor at Duke University, and I represent the cool accent at this.
Every panel needs a good accent.
Exactly.
Hi, I'm Maria Malikina. I am currently a fourth-year doctoral student here at Georgia State in clinical psychology. And my research focus is on psychopathic personality traits in children, and that's it, no. Recently gotten very interested in schizophrenia and specifically how it kind of plays out in the legal system.
I'm Andre Davis, a federal appellate judge, resident in Baltimore, and I was on the earlier panel. And I'm glad to be back.
All right, so we're going to go ahead and get started talking about particularly the issues that this panel is covering, and it is whether or not we should medicate a defendant either to reduce their level of dangerousness or make them competent to stand trial. And particularly, the case that we're going to focus on is one that many of you probably remember from the news. It's Jared Lee Loughner, and he was an individual in Arizona who, there was, I believe, a campaign rally for Gabby Giffords, and he attended that and shot 19 people, murdered 6 of them, including a federal judge, and another 13 were injured, including the Congresswoman herself, quite seriously. So in the course of that, he was arrested, and then he was quickly determined to be incompetent to, or not competent to stand trial. So the federal judge in that case committed him. And then it became clear he was diagnosed at the facility, the mental health facility, with schizophrenia. And they decided he presented a danger to himself and to others, so they wanted to administer medication to him. Psychotropic drugs in order to reduce his level of dangerousness. And there were 3 separate hearings held. They're called Harper hearings. And it's a little bit different than what we look at for competency to stand trial. This question, the threshold question here was, can we medicate this person against his will because he said time and again, I will not take the medication. So can we medicate this person against his will to combat what they perceive to be the dangerousness issue? And from a legal standpoint, it's doctors who make the decision when we're talking about this person's dangerousness, but it is judges who make the decision about medicating someone to essentially force them to be competent to stand trial. And so he had 3 separate hearings because there were a variety of procedural issues about whether or not he was allowed to have witnesses at the Harper hearings, whether or not the social worker was representing his best interest during those hearings. But over the course of those 3 hearings, every single time, the doctors, in fact, concluded that he should be medicated against his will to reduce his dangerousness. That ultimately was appealed to the Ninth Circuit Court of Appeals, and there the court said that it is, in fact, perfectly fine. There was no deprivation of due process or any of the constitutional rights that we normally talk about in these types of cases, and that in fact it is appropriate to have medical doctors determine that this person should be given psychotropic drugs against his will in order to reduce his dangerousness. And so that's sort of where we're going to frame it from. We're going to be examining issues of not only medicating them to make them less dangerous, but also medicating individuals against their will to make them competent to stand trial. And so I'm going to start with Judge Davis. You know, this case hits a little close to home. It was a federal judge who was murdered. And what are the considerations for a judge on the bench when looking at these types of issues of saying, even though you've denied the request to take medication, we're going to make you do it anyway?
Well, Lochner, and refresh my recollection, by the way, the case is over.
It is.
He pled, he's been sentenced, so it's over. So I'm free to talk about it, which I would not be and am not free to talk about any case that's actually pending. Lochner was a particularly challenging case, especially challenging case because it involved the convergence of two lines of legal authority, the Cell line, which Stephen talked about this morning, and the Harper line. And I have to say, I think it's fairly rare for a pretrial detainee to present with dangerousness issues. Of course, given the background of the case, it doesn't surprise us, I suspect, with regard to the Lochner case, that both dangerousness and competence converged and required of the trial judge and ultimately the Ninth Circuit resolution of how we play this out. I have sat on a number of cases, or hearings, I should say, both as a trial judge and as an appellate judge with regard to competency, and one or two with regard to dangerousness in the sexual offender field. So I have quite a bit of experience thinking about these issues from the judicial perspective, from the legal perspective, and it raises lots of concerns for me. On the competency side, I published an opinion 4 years ago, United States versus White, in which, over a dissent, I and my fellow panelist, Judge Keenan, who also wrote a concurring opinion, really, if I must say so, grabbed a hold of cell factor number one, which you will recall has to do with the question of whether the government has a significant interest in forcibly medicating a recalcitrant pretrial detainee in order to make him or her competent to stand trial. And we said no in that case over a dissent. And the standards we articulated in giving meaning to the cell test, and particularly prong one of the cell test, is rigorous, and some might even say expansive. And I tried in my writing to make it clear to the district courts who would decide these issues that the Supreme Court in Cell really meant what it said when it said forcible medication of incompetent pretrial detainees should occur in limited circumstances. And I pointedly noted that on the facts of the White case, which I'll be glad to allude to if it's appropriate later on, to permit forcible medication under those circumstances would turn forcible medication into a routine practice. Frankly, I see a lot of evidence that it's far too routine in federal court, in my opinion. And I've actually dissented from a couple of cases in which now I guess the tables were turned. I was in the minority and felt that in order of forcible medication should be reversed, but I couldn't persuade one of my other colleagues. So it's very difficult for judges, and we can talk about that. On the dangerousness side, and again, Lochner is unique because there's a concern in such a case that in pursuing the dangerousness, resolution of the dangerousness claim, you sidestep the more stringent requirements of cell and render a pretrial detainee competent for trial or for guilty plea under circumstances where, but for a claim of dangerousness, perhaps that would not have occurred. Let me conclude by simply noting that I strongly agree with Stephen. I disagree with a couple of things he said this morning, by the way, as you'll recall. Stephen said he thought all felonies were sufficiently serious to justify forcible medication if the other criteria were satisfied. I strongly disagree with that. We have over-criminalized, we have over-felonized so much that it simply is not the case that all felonies are equally serious. But the point here is that to the extent, I do absolutely agree with Stephen that counsel should be afforded, absolutely, counsel should be afforded when a pretrial detainee is made the object of a forcible medication order based on dangerousness. Under those circumstances, as we see in Lochner, it should not be left to the deferential review of medical professionals as to whether forcible medication of psychotropic medications is appropriate. So I'll stop there and we'll have a chance for further elaboration.
So, Maria, tell us a little bit about, I think it helps to, what are these medications that are getting administered and what exactly are they doing to the individual?
Well, specifically with schizophrenia, in regards to Lochner, schizophrenia tends to have positive and negative symptoms, with positive symptoms being like hallucinations, delusions, disorganized thought, and negative symptoms being more like lack of affect, lack of emotional expression, other cognitive deficits. And psychotropic medications tend to work much better on positive symptoms and not the negative symptoms. And so even though, and typically it's more of that individuals with schizophrenia we kind of turn down their outward expression of schizophrenia, but not really doing much for what's happening internally in a way. And there's quite a bit of side effects to these medications, which include, sorry, I have a list here. Things like, so medications, as far as, they tend to reduce the symptoms, but they don't really do much for the actual condition. They don't stop the condition, they don't reverse the condition. They may slow it down, which also, of course, the efficacy depends on the type of schizophrenia the individual exhibits. And other side effects of these medications are things like development of metabolic syndrome, weight gain, onset or worsening of diabetes mellitus, lipid abnormalities, fever, muscle rigidity, autonomic dysfunction, headaches, movement disorders, other things like, which may include actually the increase of psychosis, altered mental states, and all of these things severely impact concentration and function. And so for me personally, looking at, I think definitely dangerousness and competence are separate issues, but the competence piece of it is something that I think would be greatly affected by medicating as well.
Well, and I've had cases where they've medicated my client so much that it essentially rendered my client a vegetable, but yet competent still to stand trial, even though they basically can't participate in their own defense. So, Kate, why don't you add more to that in terms of, you know, the court told us we don't have to consider side effects, but are we even really treating the condition? Are we making them more competent, or are we just basically making them, you know, not so rowdy or less dangerous? Or
Sure. So I think sort of part of my few minutes, I think we'll address some of that and let me know if I don't. So there's obviously sort of two ways to talk about this case, and one is to address the procedural issues, and I do not have the background. There are clearly people here who are much more able to do so. And then there's the substantive issues, not legal substantive issues, but I think clinical substantive issues that are very important for us all to be on the same page as we go forth. So I will start out by saying that I have a strong opinion about this, and it is that individuals who are presenting with severe symptoms of psychopathology and are presenting as a danger to themselves or others, and in many cases, in many jurisdictions, are unable to care for themselves in extreme ways, require medication or some sort of treatment. It would be in fact unethical, it would go against our standards, our clinical standards, to not provide them the necessary treatment. It is essential to do so, and as we sort of go forth, I'll explain that a little bit more. The issue here is that we need to understand, for those of us who have seen individuals sort of from an anecdotal perspective, seeing an individual in the midst of psychosis is incredibly harrowing. These are not individuals who are happy to be experiencing these symptoms. They are at the bottom of, they're sort of in the midst of a tornado that they do not see an end to. Now, of course, I am describing a heterogeneous group, but it is incredibly important to understand that this is not a pleasant experience. As we see with Lochner here, they put him on suicide watch. Now, I don't know exactly what happened there, but they put him on suicide watch because they were concerned that he would kill himself. It could have been for a number of other reasons, but there is an experience that none of us would want to be a part of. And the problem is when you're inside this tornado of mental illness, or extreme mental illness, not all mental illness, you're often unable to see that there are edges to it, that you can get past this if you were to get medicated. Now, to be fair, we obviously want to care about autonomy of the individual. And if an individual is not presenting as a danger to others or themselves, we leave them alone. If they don't want to take medication, we don't enforce that medication on them, and that seems fairly reasonable. It would probably be best if we could. However, there is, of course, in this group, there's, of course, sort of a thinking about the paternalistic component of us as the state or as clinicians to enforce this medication on them. The idea here is that we could see potentially things that they're unable to see in this particular moment, not forever, not even for a very long time, but for a limited period of time, that these medications can alleviate the symptoms of which they're unable to sort of discern in the moment that they are. I think, in fact, this really is, it reinforces the idea of human dignity and that we are going to provide these individuals with some of this. This is not a new idea. This is an idea that has been talked about by many people. I think it was best described by Paul Applebaum and Tom Guttal, some of the leading forensic psychiatrists of our days. They wrote a paper in 1979 talking about the problems with the court being unwilling to grant treatment over objection, or sort of the broader issues of medicating individuals and keeping them in various facilities, and they called this article Rotting with Their Rights On. And I think it speaks to the issue. It gives a visual manifestation of sort of what it is like for people who are suffering from psychosis. So let me see. The other points that I want to make is, again, sort of that this equating treatment and punishment are not necessarily the same thing, right? So in this situation, the way that the case, and this is a factual issue, and I sort of won't speak too much to it, but in this case, obviously the conundrum is that if you force someone to get medication, you also invariably make them competent, or likely to make them competent. And this was exactly sort of what the court talked about. This is entangled. The problem, though, of course, is from a clinical stance, the issue is immediate. This is an individual who's presenting with extreme symptoms of psychosis or otherwise that is making him or, in other situations, her, unable to proceed in any sort of situations, much less competency or anything else. Right? And therefore, they're a danger to themselves by potentially hurting themselves, throwing chairs, as it sounds like in this case. To me, sort of as I try to reason about sort of, how would the court sort of separate this, the idea is this: would we provide other types of treatments for individuals that we thought would then go on to commit horrible crimes? So if we have an individual, and yesterday I was in a panel for the sexual offenders, will we provide medical treatment for people who have pedophilia and have a very high likelihood? Yes, we would. We don't really care that if we didn't provide them some sort of medical treatment, it would actually potentially reduce their chances of committing the crime. We only care about in the moment we need to provide them the treatment, and that's sort of the issue that is before the clinicians in determining whether or not to provide this treatment. Now, the question of who should be making this decision, should they be provided with sort of legal counsel? I think it would be very important for them to receive legal counsel. They get legal counsel in civil settings. I mean, this is sort of a separate issue. The second point that I want to talk about is the cell case as it relates to this. First, it's sort of to frame this, being competent is not a bad thing, right? In fact, being competent is what our criminal justice requires because it's generally a good thing. Now, it doesn't mean that in many cases this can't be a defense strategy. As Professor Morse has talked, that there's obvious reasons for why we might not want, the prosecution might not necessarily be pushing too hard or in this case detaining, but there's the Riggins case and all that, but really being competent is generally a positive thing. So when we get this medication over objection and sort of treatment, whether it be through cell or through the Harper line, what happens? Well, there was a great paper that came out by Bob Cochran. It was just this year, and he reported on 6 years of individuals who were in federal prison under the cell criteria. So first, just to give you some of the numbers, and I thought those numbers were really fascinating. So out of 90,000 defendants that go through federal courts on average, about 300 to 400 of them go through competency restoration programs, and 287 over 6 years, over a span of 6 years, were sent for involuntary treatment. So they went under the cell case, and out of those, 133 were granted. So you could see, first of all, they're not granted all the time. Now, out of those 133, they had remarkable recovery rates. 79% of those 133 responded to the medication and were found to be competent to proceed with their case. Now, I don't have the timelines. I don't know exactly how long it took. I suspect, as again, Professor Morris noted before, restoration of competency with medication is not an extensively long process. It can be, and when it drags on, in sort of many cases, that's clearly an issue. But when it doesn't, it's a fairly short process. So I think to sort of use the information from that, to me it seems like it would be important both for a justice perspective to have individuals that are competent, and knowing that we can restore them fairly effectively, and knowing that this is not done in many cases, right? These are extreme cases that should be handled with extreme caution. It would be important to sort of course, delineate sort of which way we go about it and the procedural safeguards that are in place. But to do so, we can do so confidently and sort of successfully, and if we can, to sort of proceed with this.
And when you say restore competency, what does that mean? Is that a sliding scale, or is there a threshold of functionality that you're talking about?
So it's an issue of sort of functionality, right? And it's generally it's an evaluation for competency to stand trial, and there's standard criteria. Now, as was mentioned earlier, of course, the functionality component is going to vary between making a small decision versus making a larger decision. Now, the court has disagreed with it. They said there's really only one standard of competency, but when we think about it from a clinical perspective, we say that some individuals might have the ability to say, speak to their lawyer and be present for their case and provide certain types of information, but really would not be able to testify because of some certain issues that would get into place. Now that's sort of a simple example. The more likely scenario is that the more complicated the case is, the more abilities you really need to have in order to be able to deal with the complexities of that case. So I wouldn't necessarily say it's a sliding scale, but it is highly dependent on functionality and sort of the context of the case.
And so we've talked about there's legal issues, there's medical issues here. So there are also ethical concerns. Felipe, do you want to talk to us about that?
So, unlike most members of the panel, I actually haven't thought a whole lot about these issues. So when I received the case a few days ago and I read it, my first reaction was that it seemed to me that by giving the psychotropics to the defendant, they were trying to kill two birds with one stone, as it were. The bird of dangerousness and the bird of competency. But of course, they need not go together. There are lots of strategies to reduce the dangerousness of an individual that do not involve pharmacological interventions, from restriction to giving other kinds of medicines that don't necessarily have to mess up with your nervous system. And then there is, of course, the other concern, which is the antipsychotic drug can render the person less dangerous and less violent in trial, but also render them incompetent for other reasons outside of the original problem that they have with schizophrenia. So surely, if you ask the individual to ask a question and their response is pragmatically incoherent, you say like, were you there such and such day, and says, I can see pink flamingos in front of me. That's pragmatically incorrect, and you say this person is not competent. But asking the same question and getting a nod after 5 minutes does not seem to be a competent answer either, if it is pragmatically correct. So I worry about reading reports of this person was rendered competent after the administration of the drug, when competence is applied so incredibly lax, in such lax manner that just nodding after 5 minutes is treated as competent. So you read those numbers as rates of recovery and really good thing of giving this because they are rendered competent. But I wonder whether they really are competent in the sense in which it's a good thing for them to have received the treatment. The other thing that I thought after reading the case for the first time is that, and it has also to do with the notion of competence, is that it seems that competence seems to shift in its standards depending on the moment in which it is judged across the trial. So right before, in the previous panel, there was a discussion as to whether you should be administering these drugs, these psychotropics, prior to receiving the sentencing. And then there was the discussion as to, well, why do you want to know or be competent to understand that you're going to be killed if you're going to be killed next week? And it seemed to be perfectly reasonable that certain considerations about receiving drug at that point shouldn't matter if you're going to be killed in 10 days. Side effects you might develop over the course of a year, kidney problem. Well, I'm going to be dead over the course of a year, so why should I give it that much consideration? But in the case of a protracted process, as a trial is, this consideration should weigh more. So I think that it's also important to separate different kinds of competence depending on the process, the criminal, the moment in the criminal process. And finally, something that hasn't been mentioned, but I'm curious what you guys think is, at the end, the defendant said that he wasn't sure that there was any empirical indication that the medicine that he received would make him sane again. That he was genuinely concerned, appears to say, like, I'm not going to go back to being sane. So if that is the case, if there is really no evidence to the fact that the medicine is going to render him non-sick, why not treat him as an individual who is not going to be recovered, and cannot be recovered? It's beyond medical, you know, he just cannot get rid of this disease. So why don't consider him as an individual who really is very, very ill? There's no evidence to the fact that even if we administer an enormous amount of these psychotropics, he's going to be able to be trialed like a sane person.
Paul?
Okay, so 3 points. So the first point, I remember my first encounter with this case, and I just thought, really? This guy having the informal way of talking, this guy seems to have been stark mad, even by the time that he committed this crime. Why is it that we're even putting him on trial? Why is it that we're, picking up the phone and calling the lawyer or the judge, rather than picking up the phone and calling the medical person and saying, hey, here's somebody who's just been a bit of a force of nature, and some horrible things have happened. But nevertheless, it's, there's nothing here to be answered for. And I guess the assumption is that, well, because whenever a case like this occurs, whenever a crime is committed, we do want somebody to be answerable for it. Question is whether this person and what seem like their actions were actually actions per se, things for which we are entitled to ask them to give an account. Because to the extent that what actually happened, and sorry that I'm going to put it this way, Stephen, is that, hey, the disease brought about this behavior. Look, the disease killed all those people. It's not that there was some person here, making decisions and saying, I want to kill all these individuals. Rather, there was a lot of insanity already present. Why did we even bother to say, hey, let's restore this individual's capacities in order to now ask them why they did what they did? Because the answer is probably going to be insanity or something of the sort, florid schizophrenia. This is all the more important, I think, given that before a condition, and this I learned from your awesome essay that you wrote for the neurolaw seminar, that even before we come up with a diagnosis of something like schizophrenia, you get a whole bunch of very subtle effects on people's reasoning. And the really worrisome part about subtle effects is that you don't notice them, right? If I have very obvious symptoms, I just keep hearing these voices. Well, guess what? And and they keep coming out of over there where I can see there are no people there. That's a reason for me to say, ooh, maybe my judgment might also be impaired. When I am in that stage before my schizophrenia has been diagnosed, there may be a whole bunch of different incapacities, different subtle ways in which my reasoning, my perception is being affected that I don't even notice. The very prospect of then being put on trial once I commit this crime and being asked to answer for a crime that I committed, to me seemed like a very strange thing to do. And so I'm very surprised that this guy is sitting 7 life sentences plus 130 years. That's his sentence. Wow. How do we even get that to happen? 7 life sentences. We're like killing 7 times, then bring him back to life, and then say another 140 years, please. So that's one worry. The worry about whether we even should have asked him to account for what he did, to take responsibility in the accountability sense. My second worry has to do, or second comment has to do with two ideas. One is So who precisely is competent to stand trial? Are normal people competent to stand trial? Because it seems to me that normal people's memories can be quite awful. And the simple thought there was, should we perhaps insist that before people, stand trial, that we use whatever means we can to enhance their abilities to remember things? For instance, use whatever mechanisms we can to preserve their memory or to increase their ability to recall what actually happened. And this is just something I'm toying with, so I won't say too much about that. But in regards to who should tell us what capacities are required to be competent to stand trial, so this is the assessment part. Stephen made a comment about how, well, actually lawyers are the ones in the best position, not medical people, because they're the ones who know what needs to be done in court. And the two particular competencies that were mentioned is the ability to understand proceedings and also the ability to assist counsel. And the suggestion there was that, well, because if we don't have those two things, then you won't get a fair trial. Now, I guess it's in that context that I then thought about, well, how about the rest of us? Should we, if I commit a crime, should I be given the best possible ability to get? Should we increase the ability for me to get a fair trial by giving me various cognitive enhancers and memory enhancers? But all that I wanted to add to what Stephen said was that, again, lawyers might be in the best position to tell us what competencies might be required simply because they know what these people have to do when they stand trial. However, surely lawyers aren't in the best position to assess, right? So I hope that's not what you. Okay, good. Already clarified. You think lawyers should assess as well as tell us? Okay, I'll be interested to hear why afterwards. I would have thought that somebody else should be the one who does the diagnostics and not the lawyers, or else we should train lawyers in to be good diagnosticians. And again, presumably for the same reason, lawyers shouldn't be the ones that then determine what sort of treatments should be administered, because lawyers aren't in the position to tell us which treatments might work and which ones mightn't. So I'll be interested to hear why you think that lawyers should be the ones that diagnose, but not that decide what treatments should be given. My last worries refer to the effects of treatments, and this already came up in Stephen's talk, from memory, I think. And that is the effect that these medications can have on changing a person's demeanor. So a crazy person committed this crime, but now here's this perhaps placid person who's no longer throwing things across the courtroom like what Lochner was doing, did when prior to being treated, and whether this might just be prejudicial towards him, to treat him precisely because who is it that stands before us? Well, an apparently sane person. That's the person that committed this crime, or at least not as insane a person as what he actually was. A related worry is whether or not, and the degree to which these medications may change the nature of the sort of testimony that a person gives at trial. So the content of what they say, essentially. There was the original worry that, look, maybe they may simply not be able to give any account. They might just say, well, look, now that you've restored my competence, I can't tell you why I did that. I sort of had all these strange feelings, I guess. That's one thing that I'd say. But my worry would be that they'll try to make sense of what they did, even though there wasn't any sense to start with, and that then we'll end up assessing a person's actions based on a completely fictitious story. So would it be a good idea to restore a person's competence to stand trial, and then find that they can give us an account of what they did, an account which isn't actually accurate. So, those are the 3 points that I want to make. One about why the hell are we even putting this person on trial? 2, precisely who is it that should diagnose whether the person has the right capacities? And 3, what are the effects that these medications might have on them in terms of being prejudicial to them to appear sane, and also the kind of evidence they'll then present.
think Felipe has a response.
No, not a response to the question. Is the reconstruction of the individual with the psychotic attack immediately after the psychotic attack more veridical or faithful to what happened than the reconstruction that is done after receiving the...
After some time passes.
No, after receiving the treatment. So you were saying, like, how can, you know, this person receives the treatment and makes a reconstruction and is completely fixed the issues. The alternative being doing the reconstruction prior to the treatment once the person is having the psychotic
so note, presumably before you advance to the treatment, they might just go, you know, or what? I mean, I don't know. I don't deal with clinical populations, but I would assume that by the time that we end up having to medicate someone, right? It's precisely because we can't get a coherent story from them. So we medicate them, but then we've medicated them, and now we get a coherent story, which is probably not what was going on in their head when they did this stuff. So either we can't get a story from them, or we get a story which is false. In both cases, it seems we're kind of screwed on this. We don't actually get an account of why they did what they did.
That's just a factual thing. I mean, there'd be no reason to think that he wouldn't give you, even while psychotic, he wouldn't give you a coherent account. It might be influenced by psychosis, so I'm not familiar with the details of the case, but he could, for example, say, well, this is all I could do to save the world, so that's a coherent account.
Right, so...
It would be unusual not to be able to get some sort of coherent account, although that could happen like that.
So the reason... Is it okay if I just stop?
Go, yeah.
Okay. So the reason why I bring this up, right, is because I'm not in a position as a philosopher to know exactly what this clinical population might be like. So is it the case that what I've just raised is simply not what actually happens? It is that they'll give you some account, but it's that it'll be difficult to extract it from them or something. You know, so yeah, you're the guys that actually experience these people. I'm not. So you tell me, what is it reasonable for us to get?
Kate does have the clinical.
Well, so, I mean, I think that there's sort of two issues here. The reason that we even care about the account from the individual, right, is because for the competency component, we need them to be able to talk to their attorney to describe what occurred, and that is how the attorney is then going to build the defense or otherwise. So that's the reason that we actually need the recollection of the defendant or the explanation. It doesn't have to be precise. It has to be a general explanation, right? Now, obviously we want it to be precise.
How about accurate? Does that have to be accurate?
Oftentimes it's not. People lie to
I've
their
had
attorneys.
completely sane defendants, and it's not accurate
Right.
account.
So the issue about sort of what they sound like post committing the crime, that issue touches on insanity, right? So criminal responsibility, by describing by getting their account of what they were like at that time, psychiatrically is going to help us with the criminal responsibility issues. Can we get information from them immediately after? Absolutely. The police tend to do it all the time, right? Or at least they write down exactly what occurred, what the person looked like, or other people are interviewed. And yes, they're probably going to provide two somewhat different stories. One that might factor in things like, you know, God made me do it, or I believe this guy was watching me and therefore I had to kill them. And post-medication, post-successful medication treatment, they might say, no, you know, this guy might have been following me, but it really felt like he was just walking after me, but I really thought at that time. Now that would be a perfect restoration of sort of faculties, and that's probably not going to happen because that's also insight. But the idea is they can sound. I'm not sure that that's really a problem.
Okay, so you reckon that it's not the case that by restoring a person's competence, that they'll provide a fictitious or a non-accurate account, or sorry?
I think the issue is that I'm not sure we ever have 100% assumption that we're ever getting a perfect account, right? The account is always based on what that individual wants to share with his attorney. The only reason we care about it is his ability to communicate with the attorney. We generally, or at least as clinicians or otherwise, whatever the account of the crime is, it's only going to come through to the attorney. So really, it's him being able to relate information to the attorney.
Well, it's not even relate information. I mean, when we talk about competence on a scale, it's are they able to meaningfully participate in their own defense? And that is a range, just depending on the court. I mean, I've had death penalty cases in Mississippi where meaningful participate in a defense is a lot different than the cases I've had in California. And whether or not my client's able to communicate with me, none of that of an accurate statement matters as much as it, can you work with me on this defense, as opposed to, I need to know exactly what happened, your version, someone else's version. That's not anything we take into consideration, even aside in the fact from whether or not you're competent.
And let's be clear here. When you hear a lawyer say, as you just heard, I need to know exactly what happened, what that translates into in legal speak is, I need to know exactly what the government can prove. Okay? And so part of the difficulty from my perspective as an actor in the legal realm is that there are a number of fictions floating around what we think the criminal justice system consists of. And the truth of the matter is, and Stephen was absolutely right about this, and the last comment was right, you know, there is a range of competencies that any good, competent defense lawyer is looking for in her client. And frankly, in some cases, knowing what the client's version of what happened is irrelevant or near irrelevant. The question is, what evidence does the government have available to it to prove what the client did and what the client's state of mind was when she did it? Because that's what it comes down to. Mm-hmm. And so it doesn't, part of the problem here is categorization. And some of Richard Bonney's work is so on the mark because none of this is static. Not every felony is the same, not every crime is the same, not every violent crime is the same, and there are major differences between working out a reasonable plea of guilty to a crime on behalf of a client with a certain record of past convictions on the one hand, and preparing to go to trial to defend someone's life in a major multiple homicide murder prosecution. And so part of my criticism, if it's that, and it's not really criticism, the Supreme Court and other judges have not given the guidance that mental health professionals, the defense bar, and the trial judges need in order to work out some of these problems in a rational, sensible way that achieves the best outcome for both victims and the state, as well as for the defendant.
Okay, so...
I guess that was a mouthful, but...
So...
And by the way, Nicole, the reason it goes into the criminal justice system, of course, is because that's where everybody goes when you shoot somebody, or nearly everybody. And then we leave it to the criminal justice system as the traffic cop to decide who goes to the mental institution, who goes to prison, who goes to the mental institution within the prison, and who goes home to mom.
Okay, so I mean that was obviously a metaphor, right? It wasn't literally like, what, so here I am, whom do I call? Do I call the ambulance or do I call the lawyer? It's more like, how do we decide where eventually the person should go? But, okay, so are they able to meaningfully participate in the defense? So let me change the emphasis. Are they able to meaningfully participate in the defense? That's my worry, right? Mm-hmm. Or, without using emphasis, is there a person that is able to meaningfully participate in someone's defense? My worry is that by medicating someone, yes, you might create this person who is now able
Right.
to meaningfully participate in the defense of somebody who committed a crime, but that it's not necessarily going to be the right person that is going to be able to meaningfully participate in this defense, and shouldn't be the right person that is meaningfully
Oh, but the
participating.
law doesn't care about that.
Shouldn't it?
In fact,
Why bother? Why
They don't
bother-
care
why
which
bother-
version
okay,
of my
hold on.
client they get. They
Okay,
just
so
want a
hold on.
client who can.
Sorry, my mind boggles. So why even... No, seriously, my mind boggles. So why bother restoring them at all? Because actually, if it doesn't matter whether it's this person or that or somebody else, well, because all that matters is really the sort of representation that's going to be provided to them, well then forget them. You know, just give them treatment, put them in a nice comfy cell so they're not suffering from nasty symptoms, and allow the lawyers to battle it out based on whichever fictions they would like. But I would have thought that what needs to happen. No, seriously.
But then the Constitution, you can't. Then you've got the right to a fair trial.
But I also think there's another piece at play here that's important, right? So just because an individual is psychotic does not mean they're incompetent. In fact, you can be fairly psychotic and still be able to work with your lawyer. Most people who are psychotic are not found to be insane. Now, it's very rare that people go forth with the criminal responsibility defense, but when it is, it's often not successful. Now, there are probably many reasons for that. But the idea is that you don't necessarily, just because you are mentally ill, automatically absolved of all guilt and therefore should then proceed to a
Right.
psychiatric hospital. So whatever version of that person that you have, I'm a little uncomfortable talking about them as versions, but I think, because what I think when we think about as clinicians for mental illness, these are things that are hampering this person's functioning. It is like if you are operating without enough coffee in the morning, but multiply that by 5,000, right? So that's not the best version of you without coffee. Well, it's the worst possible version of that individual, right? So it's still them. Now, the idea is, now if you then say, okay, do we want that person working with their attorney? No, we don't. Do you want to be in court on a trial without having coffee? Probably not. To sort of now think to put that into the context of,
This keeps assuming that there's a true self there, and that somehow,
That there's a cure.
yeah, and that there's...
Fine, but to be fair, we do get improvement with medication. We get, it's more than chance improvement. This is not like we give them, now it doesn't mean everyone's going to respond. I think as was mentioned before, 60, 70%, that means 30% are not going to respond. It might take 5 different trials of medication, but most people do respond. So it's not that you get a truer version, again, and I think maybe because I don't have a philosophy background, so this idea of truer versus non-truer is foreign to me. But you just get, say, a cleaner version of them maybe? I'm not sure.
but here's the problem with that, from the perspective of at least one judge's view of the legal system. And this is one of the cases I sat on. If all we're doing is restoring competency sufficiently profound and sufficiently long to permit them to plead guilty, and then ship them off to prison after a guilty plea, where because they're not a danger to themselves or others, they can no longer be medicated, what have we achieved? And more importantly still, what have we achieved in what I consider to be that large category of felony cases that are not violent offenses? What have we truly achieved, other than just some efficient cogs in the mass incarceration machine that we've become? And so that's what I hope more trial judges will think about when they're asked by the government, in effect, Judge, let us inject him forcibly for a few weeks. He'll be competent enough to come in and plead guilty, and then we're through with it. You've got a case off your docket. we've got a new conviction, and we're finished with it. I don't think that's the world we want to live in.
And based on sort of, I agree, right? I mean, there's sort of an issue of what are we doing it for? Now, dangerous obviously makes it easy.
Right.
But based on this data from the Bob Cochran study, right? More than half of the people, the cell petition is denied. So it suggests that many people are actually not forced. Now, it's not to say that 133 people over 6 years is a small number. Obviously, even one would probably be too much if it's not. But it is to suggest that it seems like it's not happening fairly frequently.
Well, I was very pleased to hear your statistics. I had not seen those statistics. And of course, there's a certain bias that I bring to this because I only see the cases where the petition was granted, and I'm looking at it and I'm thinking, what was this judge thinking? Why would he grant this? So I'd like to get a better sense of what those statistics are telling us.
If I thought the system were, as you just presented it, Andre, I would agree with you entirely. By the way, I'd like to say, I agree with you entirely, we're vastly overcriminalized. You can't address everything. I agree with lots of felonies. We have, this is not going to be any brief for the quality of prison mental health services. Jail mental health services in the United States are terrible. But once you're in prison, there are mental health services, at least medication. If you are psychotic in prison, you will get medicated if you're willing to take it voluntarily.
If you're willing.
If you're willing. And the interesting thing is, most prisoners, actually, if it's put to them respectfully and the like, they don't object. They do. They get, I'm not saying they get vitally rest homes who are very anxious, but they get bare bones psychotropic treatment in prisons. Jails are another matter. They're a horror.
Kevin, one comment in defense of memory. Because I agree with you that memory is inaccurate, but there are inaccuracies and there are inaccuracies. So if you're having a severe psychotic attack, there is a level of inaccuracy on the report of what happened that is not the same as the level of inaccuracy that you see in your normal, ordinary false memory. And part of the reason I was thinking is there is a very reasonable explanation as to how to accommodate the false information that the false memory has in the ordinary case of false memory. But it will be very difficult to find a reasonable explanation to accommodate the inaccuracies in the report of the individual in the psychotic attack. Now, and it's important to see whether the same degree of difficulty in accommodating the false information carries over after they have gotten the medication. Because it might be possible that once they've received the medication, the report is closer to the ordinary false memory than it is to the initial fictitious, and this is, I think, to credit the psychopharmacological industry that do a pretty good job at times and making medicines that actually do help. So I think that there are degrees of inaccuracy, and I wouldn't just compile them all together.
Indeed, and there are also, I want to come back to something that you said, but I just want to address this. So note that there are also, I can intentionally keep things from my lawyer and not tell them certain details. But when I do that, the inaccuracy that results is something for which I'm responsible, and that seems to be somehow important as in comparison to the inaccuracies that might result as a consequence of mental illness. So when somebody reports inaccuracies because they're mentally ill, and then we base our treatment of them, we punish them, given what they've told us, that's very different to what happens when they intentionally try to deceive us, and maybe we buy that. Right, they're successful. So part of the reason why, look, I agree with you. Accuracy isn't really the issue here. Something else is an issue. Nevertheless, some kinds of inaccuracies are inaccuracies that we bring into the system, and well, the criminal justice system is fine with them. But other ones we shouldn't be fine with. And so those are the inaccuracies that I would like to, eviscerate. And that's why I'm banging on about it, because I do think it's kind of important to. Not to say, well, look, as long as their legal representatives can battle it out with one another, then there's a fair trial. Well, no, I mean, surely some, the person does actually matter in this picture. But, okay, why are we doing this? If only to get a guilty plea, right? So why bother? Wouldn't it be just better to simply say, look, forget about forcibly medicating them, only so they can plead guilty. Let's just shuffle them off. My worry there is that this is still, I agree with you. Like, why are we doing this? And at the same time, I also worry that, well, perhaps what we're trying to do is to find a way to at least bring some of the person's own agency into the system, such that it's not just that the system provides formally a fair trial, even though the person themselves doesn't actually do anything, but to ensure that, well, even if in the most, in the smallest way, it was their decision to plead guilty. I mean, that's really why we're doing it, right? Or is it?
I don't think so. And one of the things I've thought about, on the civil side, we have this office called Guardian Ad Litem, which, for children in custody battles and in loss of capacity for the elderly and for the traumatically injured, we have legal infrastructure in place on the civil side to permit surrogacy, surrogate decision-making. And frankly, while I haven't thought about it deeply, I admit, it's not obvious to me why we couldn't have such a legal infrastructure on the criminal side, so that in addition to a lawyer, and of course the main objection here is going to be, who's going to pay for this? Well, taxpayers are going to pay for it. But in addition to a lawyer, there could be a surrogate decision maker, perhaps a relative, perhaps someone else, so perhaps an officer of the court, who could assess together with the lawyer and in consultation such as it is with the mentally disordered defendant, and make a reasonable decision about some of those alternatives that Sel talks about. And so I agree with you, Nicole, some of these cases simply ought to be dismissed. And contrary, again, to what my good friend said this morning, I can't think of any really compelling reason why a dismissal of charges where that is otherwise appropriate of a mentally disordered and incompetent defendant must be with prejudice. You could put it on the shelf and you could bring the charge back 2 years, 3 years, 4 years, 5 years later. Now, there are lots of details to be worked out in that, in terms of prejudice to the defendant, loss of witnesses and that kind of thing. But there's no compelling reason, to my mind, when a person has been in pretrial detention for a period of time that begins to approach the likely sentence that he or she would receive upon conviction and a reasonable guilty plea, why forcible, compelled medication is a more sensible, a more rational, a more constitutionally permissible outcome for the government. I just don't see it.
I think it follows on. I mean, one of the things I'm a bit surprised at this conversation is that nobody's mentioned the person's decision-making capacity with respect to having the treatment which will get him capacity for the trial. I mean, surely that's an important thing. So if they have decision-making capacity, even though they don't happen to have, for the medication, even though they don't happen to have competence to stand trial, well, then you can just ask them. And if they don't have that decision-making capacity with respect to consent for the medication, which would give them capacity to stand trial, then a substitute decision-maker would be the appropriate. I mean, I just don't know why you wouldn't set up that situation.
Well, I think it does, and I think that sort of in this particular case, the issue was that once you do provide them with medication, and they now become sort of okay for say dangerousness issues and are now able to make other decisions. The problem is you sort of automatically made them competent without meaning to make them competent. Okay, is that sort of what you were addressing?
So I've made them, there's two sorts of competence. So there's the competence to refuse the medication. So the guy's refusing medication.
Right.
But he's not really refusing medication because he's just voicing the words, I don't want medication,
Exactly.
if he lacks decision-making capacity around that decision.
Right.
So then it might be a trickier decision. The substitute decision maker has a lot of things to consider here, like is it really in his best interest to get treated? But, that would seem like the way of assessing it. That's what we usually do, isn't it? That's exactly what we do everywhere else.
Right.
I think sort of what that made me think of, and I know this has been brought up before with, when there was a conversation about end-of-life issues, is, now I'm not aware of this being standard practice anywhere, really practice, but once we have actually gotten some sort of treatment over objection, and the person does seem to be competent, is able to make decisions, wouldn't that be a great time to actually ask for some sort of a directive for the future about whether or not you would want to be restored to, say, competency or would want medication? And now you don't have to necessarily deal with this issue of having substituted judgment. Now, I don't know. I'm not sure.
Except that the next charge might be murder rather than shoplifting.
Actually, I agree with you, Andre. It doesn't have to be with prejudice. What worries me, be without prejudice, such as the charges we brought again. What worries me is people languishing in hospital. That's what I don't want to have happen. They're in legal limbo. I'm not opposed to dismissing the charges, but if they are certainly apparently still dangerous, then we've got to figure out what to do with them. We're not going to send them back to the community. We're going to have to come up with some alternative. So, for instance, in California now, if you are found permanently incompetent to stand trial, and the most they can treat you is 3 years. It's 3 years or the maximum sentence, whichever is short. So it's a maximum of 3 years. At the end of 3 years, if you're still dangerous, there's a form of potentially lifelong, with annual review, involuntary commitment. So these are people who are going to end up languishing. I'd rather, for most of these cases, get the criminal justice system completed and get it over with. But I fully agree with you. I mean, these are alternative ways of getting the person out of limbo.
Well, on the other hand, that's how we treat those found not guilty by reason of insanity. They go away, they have a periodic review, they get furloughs. I mean, we all know the Hinckley case.
But their legal situation is clarified.
Yeah.
They've been found not guilty by reason of insanity, and if they are ever either no longer mentally ill or no longer dangerous, they must be released. And, it's clarified. They're not in limbo, basically. Yes, they're in commitment, and that is a dreadful thing, but they're not in limbo.
There's a question.
Yeah, it's fascinating to listen to this because it seems like we have, in many ways, competing systems, competing discourses for how to deal with behavior. So a person engages in some behavior. They shoot someone. And one group of people immediately think, why did they do that in terms of what was their mental state? And another group, why did they do that? Or how should they be dealt with since it violated this rule? And another group is like, well, what's the moral status of their action? And so in some ways I think the reason we have these panels is because we'd like to get everyone together and get one big coherent system that makes it all work out. But I think the weight of history is going to make that extremely difficult because you can see that we have very different historical traditions and assumptions about what should be done, what should be analyzed, what should be thought about these people. So there's lots of things that could go with that. But let me ask just one tiny aspect of this. I think because in our system, physicians are the gatekeepers of the stuff that we call drugs. We automatically think, and we've seen the term up here a lot of times, that if you use this pharmacological agent to affect a person's mental state, that counts as medication. And thus we have to have a medical specialist make a determination, and then we call this treatment. We talk about it being medicine, and then the law gets involved, and whether or not we should use the medicine. But another way to think of it, and I'm not saying this is a good thing, but to recognize the great disparity that we have between these systems in society is to not think of it as medication or treatment at all. What if instead we just thought this is a pharmacological agent that can induce a legal state that we require for this particular person to continue through the criminological system? In that case, it would literally not be medication. Medication is a functional description of what this set of molecules will do. And in that case, we simply, and not to say that they couldn't be treated in another context, but we simply would not need to involve medical clinicians, medical personnel at all, because the agent that we're using is really about a legal status, not about a medical treatment. Does that make sense? And in that case, the lawyers would be precisely the ones to decide what should be done and how much they should be given.
Yeah, I worry though that you probably have a more clear view about this. This pharmacological agents have an enormous amount of side effects that would be clinical, and it would be very risky to say we don't need medical doctors here, and the individual who is receiving this pharmacological treatment gets into cardiac arrest. Lawyers are not very well.
I'm certainly not saying cardiac arrest, of course, would be important,
But
so would be
a lot of
having someone in jail. You have to have.
Yeah, but well, that's a different issue. But I feel that the reason I take it that doctors and clinicians are called is because the administration is not without its medical risks. Now, whether only a doctor ought to be there, or if the doctor ought to be there for the reasons of administering this, that could be a different way of putting the same concern. But my take it is, for what I read in the case, is that was one of the main reasons, because it does convey some medical.
But I think also sort of what that's missing is the idea is just because we give them medication doesn't mean that they're going to be competent. Now, in this study that I talked about, a large proportion of the people became competent as a result of medication, and potentially some groups that were present in some of the federal facilities. But giving them medication on its own is really does not mean that now you've taken it, you're good to go. And again, what we are assessing as clinicians when we make a determination about competency, and I'm not a medical doctor, so sort of the side effects, I have some idea, but would not be able to treat them. We're assessing a functional capacity issue. And absolutely, would attorneys be able to do it? Yes. I think sort of what to me feels like is a unique contribution by clinicians, and obviously I'm biased, is that the idea of providing an explanation of sort of the reasons behind some of those functional limitations, and fairly non-specific explanations, right? So why this person is acting is where I think the clinician could be helpful.
But would you say that it was a clinical decision to give these substances to people who had been ordered by the court to take them? Or was it a non-clinical decision?
So in my personal...
That's a great question.
Sorry.
Go ahead, I'm sorry. I want to hear your answer to
Yeah.
that question.
In my personal opinion, do I think that this should be an administrative hearing versus a judicial hearing? Is that sort of what you're asking? I think that there's no reason why this shouldn't be a judicial, and in fact would probably be a more fair situation than an administrative situation.
The question is whether giving someone medication or a chemical agent for these purposes is that a clinical decision or is it a non-clinical decision, whoever makes it?
That's the question.
Okay.
Seems like it's a legal decision right now.
It's a legal decision, but it's made by doctors who are employed by the prison system.
What makes it a clinical decision? It is a clinical decision if it isn't for the well-being of the individual who's going to be taking. So when you go to the doctor and the doctor makes a clinical decision as to whether you should take Advil or not, the presumption is that the doctor is hoping that you're going to get better with that, and that makes it a clinical decision. Because if that is the case, then I don't think that it's a clinical decision in the case of the trial. It looks very legal decision. So what determines whether something is or is not a clinical decision? If it is the well-being of the individual as opposed to the dangerousness or the competency here, it doesn't sound very clinical to me. If what makes a clinical decision is the fact that it is made by a clinical professional, that's a different kind of definition of clinical. So if what makes it clinical is the well-being of the individual as opposed to other extraneous reasons, it doesn't sound.
And it seems to me you're absolutely right. And part of my difficulty, again, drawing on the small sample of cases that I've examined, both sitting on them and reading, frankly, some judges think they're making a clinical decision. I mean, that's how they approach it. And it clearly is not. I agree with you. It's not a clinical decision. It's a legal determination. And the Supreme Court has told, I'm talking now about competency, not dangerousness. The Supreme Court has said in Sell that it should only apply forcible medication in limited circumstances. The government has the burden of proof by clear and convincing evidence, which is another one of my bugaboos. In so many areas, it appears to me, for reasons I can't entirely explain, judges who know better have overlooked the difference between preponderance of the evidence and clear and convincing evidence. Frankly, I think if judges paid more attention to the role of the burden of proof and the assignment of the burden of proof in this area, we would have better outcomes. That's what I think. I think too many judges apply a preponderance of the evidence. And for you non-lawyers, when we talk about preponderance, we mean just slightly more likely than not.
51%.
Not even 51.
50.1.
Not even 50.1. 50 point something. And you can add as many zeros as you want. And clear and convincing, of course, we can't quantify any of this, but clear and convincing falls somewhere between beyond a reasonable doubt and preponderance. And again, we can't quantify it, but my conception has always been, it's really up there. It's really up there. It's the kind of decision-making we require when you disbar a lawyer or delicense a doctor for misconduct, to terminate the parental rights of a neglectful parent. These are very, very serious legal determinations that don't rise to the deprivation of liberty that we see in a criminal conviction, and thus beyond a reasonable doubt. But these are decisions that are really way up there and have an enormous impact on the lives of people, and erroneous decisions have significant adverse consequences to people who should fare better. And yet when you look at how some judges apply the law in this area of forcible medication, I'm seeing, and similarly, commitment of sexually dangerous individuals for lack of volitional control, I'm seeing what appear to me to be a lot of decisions based on a preponderance of the evidence.
And a high level of deference.
Yes, at the appellate level. And at the trial court level, deference to physicians.
Absolutely.
So I want to go back about 25 minutes ago, because I'm confused. So is the question just about cases that are like the Lochner case, or is the question, does the question include persons who are waiting for trial, where it's an open question that he or she was sane during the commission of the crime, or the alleged crime, and now is judged to be incompetent? Are we talking about those sorts of cases as well?
I'd say yes.
Yeah, I mean, those are certainly included in this.
Okay, so here's my confusion then. So forget about the Lochner case, take any sort of case like this then, where it's at least an open question. Then I'm still not clear about some of the responses to Nicole's third point. Because I think what some of you were saying was that it wouldn't be terribly relevant to try to restore the person's competency in order to find out, say, his or her version of what they intended to say during the commission of the crime. No, I told you I was confused. So, but I thought that some people were suggesting that, no, that actually does not matter that much.
It doesn't matter much at all.
Okay, then I'm really confused. How could it not matter if, say, for, criminal liability, what I intended is supposed to be?
Well, I think you're
Well, because when you walk out of Walmart having stuffed 5 packs of deodorant down your pants
You saw me?
without paying for them, the law doesn't care what your intent, the law doesn't care what you say your intent was. You might say, my intent was to take this deodorant to my car, find the change in the console, and come back and pay for it. The law doesn't care about that. The law is prepared to say you intended to steal. And the law is prepared to say prima facie, when you show up at a congresswoman's community meeting in the parking lot of a shopping center with a Glock, and you empty the magazine at all the human beings standing there, the law is prepared to say prima facie, we know what your intent was. It's clear. You actually achieved your intent. You killed 9 people and wanted to kill more. Now, then we go forward and we try to figure out whether there are any justifications or explanations or mitigating circumstances around that.
But what if you find out that I'm embezzling from my college?
That was your intent, to get more money than you were entitled to. That's it. The law isn't concerned with your philosophical life. Yeah.
Most people with mental disorder form the mens rea. In fact, it's their crazy thinking that gives them the reason to form the mens rea. As Judge Davis said, the real question comes up at affirmative defense. Is there some kind of excuse?
And by the way, and then I'll be quiet, there is no connection whatsoever, at least not necessarily any connection, between mental state at the time of the offense, whether it's diminished capacity or insanity, pre-Hinckley insanity or post-Hinckley insanity on the one hand, and the mental competence of the defendant at the time of trial. Remember,
those are
two separate, temporally and logically totally disconnected. And there is no particular connection or relation between the kind of an offense and mental competence at the time of trial. 6 months later, 9 months later, a year and a half later, I'm told now in Baltimore City State Court, you don't get a trial for virtually anything for these 15 months because of the backlog. And for people who are detained in these god-awful detention centers, as Stephen said, people not only lose their minds after they've been sentenced, but their mental health deteriorates significantly in some of these overcrowded, poorly run, poorly organized places like the Baltimore City Detention Center.
And I think those are excellent last words.
Oh, can't we end on a more positive note than that?
Check out the next sessions.
Thank you very much.
The judges are working hard, I will say that.